Virginia, again, Virginia, and it seems often that we come back to Virginia, but Virginia had a lot of issues, the best way I can summarize that. So Virginia is not unique here, but it serves as the backdrop for the case because of some location issues. Virginia, like a number of other states, had laws preventing interracial marriage, and they did that by making it illegal to marry outside of your own race. So in this particularized case, two residents from Virginia, one white and one black, were married in the District of Columbia pursuant to laws that made it legal in 1958. So they were legally wed in the District of Columbia and then moved back to Virginia. So shortly after their marriage, they returned to Virginia and established their home life. Shortly thereafter, they were charged with violating Virginia's ban on interracial marriage. They pleaded guilty. They said, yep, we totally did that. And each was sentenced to 1 year in jail. However, the trial judge suspended the sentence for a period of 25 years on the condition that the Lovings leave the state and never return to Virginia together for the next 25 years. So the trial judge said, I'm not going to sentence you to a year in jail, but I'm in effect going to banish you from the state of Virginia for 25 years, or you will have to serve a year in jail. In sentencing the couple, the judge, who seemed so very benevolent before, had this to say at the sentencing. Almighty God has created races, white, black, yellow, and red, and placed them on separate continents. And but for the interference with his arrangement, there would be no cause for such marriage. The fact that he separated the races shows that he did not intend for the races to mix. This is the trial judge in the case. So after abiding by the decision for 5 or so years, in 1963, the Lovings filed a motion in the state trial court to vacate the judgment and set aside the sentence on the ground that the statute in question violated the 14th Amendment. They waited nearly a year, during which time their motion was entirely disregarded. So the state of Virginia just got this motion and ignored it for an entire year. Most states, and I can tell you this because of how states have sort of suspended and changed their laws under COVID, most states have a 60-day waiting period on which all motions have to be decided. So the fact that this lasted a year without response is purposeful. So given the complete absence of response that they received from the state of Virginia, they filed the case in federal court in an attempt to have their convictions vacated. But before the federal court could actually hear the case, the trial court that they had originally submitted their motion to made its decision against the Lovings, and the Lovings then appealed their decision to the Supreme Court of Virginia. Since the state would now hear the case, the federal district court stayed the action pending the determination of the High Court in Virginia. So while the two cases were going on, the federal court said, hold on, we will hold off making our decision pending what the decision of the Virginia Supreme Court is. The Virginia Supreme Court upheld the constitution of the anti-miscegenation laws prohibiting marriage outside of one's race. And after modifying the sentence, affirmed the convictions. And fairly quickly, the US Supreme Court accepted the case. So I use the timeline here for a purpose, and I talk about it very clearly for a purpose. What happened between the time of the original marriage and conviction and the subsequent 5 years later? The success of the civil rights movement at the national level. And so what motivated the Lovings to bring this case was the success that they had seen with the civil rights movement more generally. And so they chose not to challenge their conviction and sentence until, at a minimum, they saw the trajectory of where the law was going. And so the issue before the court, was the Supreme Court, was whether Virginia's ban on interracial marriage violated the Equal Protection Clause of the 14th Amendment. So, in a unanimous opinion, the court held that yes, it absolutely does. The argument of the state of Virginia is interesting. The state argues that this law was different from other anti-miscegenation laws that existed within the US because it subjected both African Americans and whites in interracial marriage to the same penalties. So in this case, both of the Lovings received either a 1-year jail sentence or the 25-year banishment. That was equal for members of the both races. So their argument was it wasn't equal protection, that there was no equal protection violation because in this case, they clearly had individuals of different races and they were treated absolutely equally. It's an interesting particularized argument that the Supreme Court absolutely and utterly rejects. They held that it's an invidious classification that's based solely on race. 2 African Americans who got married were not subjected to this law. 2 whites who get married were not subjected to this law. That this only came when individuals of different races were married, and therefore it's a race-based classification, and it's invidious. And so the purpose behind this was very much citing the statement by the trial court judge was absolutely about keeping the races separate and was absolutely a racially charged law and decision. But the Supreme Court absolutely does not stop there. The Supreme Court holds that the 14th Amendment due process rights were also violated. So understand equal protection rights are violated, treating different peoples equally. The court also says that the 14th Amendment's due process rights are violated because marriage is a fundamental right, and the state cannot deny that fundamental right. They go back and they cite Skinner as marriage being of fundamental nature. And so again, you can look at the Constitution, you can see that nowhere in it is there a discussion of marriage. It's absolutely not there. But via the 14th Amendment, the court reads in marriage to be a fundamental right, much more broadly than it had in Skinner, to the point where they include interracial marriage as a fundamental right. But the writing of this decision is interesting because in 1967, the court didn't write its decision in a very narrow way. They wrote it in an exceedingly broad fashion, that marriage is a fundamental right. Loving v. Virginia is ultimately cited in Obergefell v. Hodges as the justification to legalize marriage between same-sex partners. So this fundamental right of marriage, which starts with the sterilization of criminals in Oklahoma, evolves to be a fundamental right of marriage more broadly across individuals of separate races to, almost 50 years later, to involve individuals of the same sex. But the same nature of fundamental right is what carries it across. And that fundamental right is incorporated upon the states through the 14th Amendment. But can we see how privacy is involved in this? Because that's how the court is getting to to it being a fundamental right is there is a privacy aspect that when two individuals decide to wed, um, the choice of whom to wed, the state can't interfere on that. That's a private choice. States can recognize the marriage. States can sanctify the marriage. They can give benefits to married couples. But they absolutely cannot determine what individuals get married. That's the privacy nature of this, that the choice is of a private nature, which should not shock you going forward to see why Obergefell cites this opinion so exactly, because the argument that is made in the future is that if marriage is a fundamental right and the state does not get to choose whom you marry, they also cannot prohibit whom you marry without some form of overarching broad principle like health and so on and so forth. And so it's an exceedingly important precedent that really doesn't come up again until the mid 2000s. But it sets the groundwork and foundation for privacy within the marital confines.